Hi, everybody, and welcome to the Outmarket.pro podcast. My name is Mark Stein, and I'll be facilitating this meeting today. Today, we have Cara Morehouse, an attorney specializing in estate planning, wills and estates, as well as civil litigation and property disputes. Before doing this, she was a supervising partner at a Tampa law firm, excelling in personal injury protection, defense, and other complex legal matters. We'll talk about her journey and her dedication to efficient estate planning and her commitment to, and this is key, I believe, providing accessible legal services to everyone in the Tampa Bay area. So glad to have you, Cara.
Thanks, Mark. Thank you for the introduction.
All right. So let's talk about your background as it relates to your passion that you have gotten for estate planning. And it sounds like from our previous conversation, it's a mission. So talk a little bit about your work in the past and what led you to this point.
Absolutely. So, a little bit of background of where I came from and how I came upon wanting to provide affordable legal services for people is I'm from a rural community in Polk County, Florida, and my parents are in agriculture. And so I grew up in a community where, hiring legal expertise, hiring attorneys could be very expensive and scary for a lot of people in that middle income bracket who don't know how much it would cost, don't necessarily want to travel to large cities, and all of the scary things that come along with the legal world. So having that background, I went to law school and was interested in estate planning because I think that it is one of the happier areas of law, believe it or not, even though you're dealing with potentially incapacitation, potentially death. It's actually enjoyable for most people because they feel a sigh of relief when they plan. And they're not involved in court, they're not involved in litigation. And so it's fun for me to meet people, to work with them, have them trust me in the two most important areas of their life, which is their family and their finances, and have that personal relationship with them, which is unlike any other area of law. So my background in the legal world is civil litigation. And in that, I've litigated all over the state of Florida. So I've been in many, many counties, seen many county courthouses. And so when I turned my practice to estate planning, I really wanted to focus on what I call probate avoidance tools. So there's no guarantee that we avoid probate. Nobody can promise you that. But we can counsel our clients to figure out ways how to try to avoid probate, which is the court supervised process of distributing your assets when you pass away. So if we can avoid having your family have to go to court to have a transfer of assets at the end of your life, which is expensive, and many other negatives that we can get into later. But if we can avoid that, then I find that people are much happier with the estate planning process and much more excited about it.
Mm-hmm. I want to start with focusing on something that you said earlier about dealing with lawyers in small communities. And I had an experience where I had a family court matter in a small rural county, not in Florida, but elsewhere. And there were only 2 or 3 practicing family lawyers in that county. And there was not another even medium-sized town nearby. So you really are at the mercy of those lawyers because their fees, since they are local, and if your case is local, their fees can be endless. So having somebody that is focused on the people and making it affordable, I think can be very valuable, especially there, but even here because and we're in Tampa Bay, because it is an unknown for most people. So I
Exactly. That's
appreciate
why
that focus.
yes, and I focus on transparent pricing. It's quite unusual. A lot of people don't want to provide their pricing up front because they'll say, well, I need to know what's going on before I quote you a price. So while that's true, and while the prices could vary depending on your situation, I give you an idea of what it's going to be. My prices, I hand out my price sheet. I'm very open about what my pricing is because I want you to know going into it what the potential cost is. Obviously, there are unknowns. There are things that come up that maybe you come to me saying, hey, I need, just a simple last will and testament. That's what you say. Well, then when we get into the planning process and you figure out the value of maybe some other tools that we have, you may decide to go another direction. And of course, that's going to cost a different amount. But at least you know up front what the range is.
Mhm. So let me see if I can guess the most common presenting not argument, but the way people present on estate planning. Well, I already have a will. What else do I need? And I've updated the will a couple of times, so it contains everything that I own. So why do I need something more than a will, and what would that be? How close is that?
That's great. To be frank, I rarely would hear that because most people don't have an updated last will and testament. They may have one when they had their kids and now their children are adults and they never updated it. Um, And that's very, very common. You're not rushing out every single time a life event happens to the attorney's office to have something updated. So there are so many different life events that occurred that may change the course of what our estate planning should look like. So just a last will and testament is fantastic, so that you can tell the court where you would want your assets to go, but that's about it. So if you want more planning than that, if that is not your goal to tell the court what you want to happen to your assets, and maybe you don't want the court involved at all, there are ways that we can work with that and work within your goals to figure out what the best strategies are for each of your assets, for your estate as a whole, and so forth.
And before we get into some of those tools, what are the typical presenting situations that lead people or that should lead people to get a will in the first place or to revise their will? What are those life events?
So the life events, I always tell people, when I'm out in the community, when I'm talking to people about why it's important to estate plan, I always say the major life events are turning 18, getting a job, getting married, having children, having a family member become disabled, having your children turn 18, retirement, and one of the biggest life events that we have here in Florida, one of probably the biggest purchases you'll make is buying a house. So if any of those things occur, it's always a good choice to reevaluate either an existing estate plan you have or to start anew. And there are some areas of law that overlap a little bit, but we try to stay in our lane. So that would be family law, real estate, and estate planning. There are some concepts that overlap, but what I try to explain to people, especially if they're in a blended family or a second marriage, anything like that, it's always so, so, so important to plan, because what you think is going to happen based on what you know from your maybe prior divorce, or what you know from estate or from family law concepts, is not true in estate planning.
Mhm. What about significant health issues? That would be one that would lead me to reevaluate.
Yes. Unfortunately, those situations are kind of the saddest to think about, because a lot of times it may be too late at that point. So if you have a significant health issue, the reality is a lot of us don't just fall ill and then say, okay, we have 6 months to plan, and maybe we're diagnosed with a terminal illness. That's not the case for most people. Most people, if something drastic happens with their health, they may be in a situation where they are incapacitated or do not have the capacity to sign those documents. And so at that point, you're at the mercy of the court.
And all the more reason to have a power of attorney already lined up to take over for you. The other one that I usually do, the other event, is when I travel, I almost always, I mean, I don't go to the attorney's office, but I'm always sharing my passwords and making sure that everything is up to date. Although we probably are more at risk when we just go to the grocery store than when we go when we fly on a plane somewhere. But I always feel vulnerable at those times and want to make sure I've got everything lined up.
Of course. Yeah, so part of the estate planning process, it's not just maybe kind of the old school mentality that, oh, I'm going to walk into the attorney's office and I'm going to tell them I want a last will and testament, and they're going to ask me, what do I have and who do I want it to go to? That's not what the estate planning world looks like anymore. We really want to know what your goals are. We really want to have a full picture of what your assets are before we get into who are you going to leave them to. Because there's a component of that lifetime planning that we don't want to forget about. So it's not just about what happens at death. There's a major component of what happens during your lifetime. And so that's, Mark, exactly what you're talking about with the power of attorney, healthcare power of attorney. A lot of people call them medical power of attorney or healthcare surrogate. It's all the same. It's all the same document. Of course, that last will and testament is after death, but there's also components to, a lot of people here are confused the terms a living will, last will and testament, and a living trust. They're all very different documents. And a living will is one of those lifetime documents where you can choose here in Florida whether or not you would want to be on life support and have excessive life prolonging procedures done. So that's something that you can choose and not have to rely on a family member to make that decision.
Mhm. So let's say I come into your office, and my situation's more complex than most people's, but I come into your office and I tell you, you know, no offense, Cara, but I really don't like attorneys, legal system. I've gotten screwed before. I want to be the least imposed upon by the court system and the legal system as possible. So let's say I have a house, I have some investments, and a little bit more. Um, what what's that conversation going to be like, and what kinds of tools might you recommend?
So to address the first part about people being wary of the court system, we have a fantastic justice system here in the US, but nothing's perfect, right? And the flaw is that it can take a very long time. So when you talk about just a last will and testament or no last will and testament, you're going to be talking about probate. And a lot of people don't realize that having a last will and testament does not avoid probate, it opens probate. So the first course of action when somebody comes in and says that they don't want to go through probate or the court system, or however they may phrase it, even if they simply say, I want to make it as easy for my family as possible. Well, probate isn't always the easiest solution because it can be very time consuming. It can be very expensive. And it's not purposefully meant to hold up the estate process and, drag it out and make your family miserable. But there are procedures in place that have to occur. And so it's not always as efficient as people may want it to be, especially if you're in that grieving process, right? So if somebody came in and they have a home in Florida, we have fantastic laws and tools to avoid probate through what we call a ladybird deed. We're one of 5 states in the US that has the ability to do this. Some other states are catching up. They have similar deeds. You may hear a transfer on death deed or so forth. But a ladybird deed is really special here in Florida. We can retain all of our rights to the property, meaning if I own a home, I can still sell, convey, modify, lease, do whatever I want with the property. I still have the tax benefits of having homestead here in Florida, and I still have the creditor protections that we have here in Florida for homestead. So creditor protection, bankruptcy protection, spousal and minor child protection. But what you can do is essentially just add a beneficiary to your home. And all you have to do is, seek legal counsel. I would strongly encourage, and figure out what your options are for naming those beneficiaries. So I would say for somebody who has adult children who are capable, who are not disabled, who are financially sound, it could be as simple as adding them, your adult children, as beneficiaries to your home. Now, there are downsides to that. I always tell people there's pros and cons to everything. So that's why legal counsel is so important, because you want that specialized counsel for your particular situation. So you can tell that attorney, they're going to ask you about your children. They're going to ask you about their capabilities. They're going to ask you what happens if one of those children predeceased you. So you can talk about a lot more the what ifs than what we can talk about here today. But it's, in short, a very simple solution to adding a beneficiary without having any major consequences that you would have if you added them as a co-owner to your home. I see a lot of people who've run out and they added one of their 3 adult children to their home because that's the child who lives the closest to them and is taking care of them. But they didn't intend for that child to have sole ownership of the house. And so you've created not only tax issues, you've created liability issues, and you have not met your goals of how you actually want to leave your house to your children. So super, super important to seek that legal advice and to know each specific situation, what you're getting into.
Yeah. I recently read an article about a couple that put their daughter on the deed, and it wasn't a beneficiary, it was on the deed. They decided to sell the house, and the daughter said, I want my part of the equity. I'm a co-owner of this house. And they started out, they were getting along pretty well. I think she didn't want to sell the house. The daughter, she wanted to get it. And so she sort of had him over a barrel.
Exactly, because that co-owner has to sign off on that sale. Unlike on a ladybird deed, if you have a remainder beneficiary, is what we call those beneficiaries, they don't have to sign off on the deed. They only have a vested interest. They only have rights to that property if you were to pass away, still owning that property. And they would inherit that property with whatever, interest you had at the time. So if there's a lien, they would inherit that lien, they would get the mortgage. They would still be responsible. They wouldn't be getting it free and clear, but you're not adding them and potentially having these consequences that are maybe unintended.
Yeah. So that takes care of the house, but if they've got other property, this couple has other property, then this is a very limited, although it could be effective if all they have is a house. But what about the other property? If they have
So
other
any
things?
other, yeah, so any other real property here in Florida, you can have a ladybird deed for any real property here in Florida. So that's a great solution to if you have a second home on the other coast, if you have a rental property. It's becoming more and more common to have single family home rentals. A lot of people are trying to get into that market and having that passive income. And so, you can have a ladybird deed for all of your real property here in Florida. If you do not have property here in Florida, so you have maybe a homestead here in Florida and you reside here, but maybe you have a family vacation home in Alabama, you can see what the laws are in Alabama and see if you are able to have a beneficiary on that deed. Or the other option is likely taking advantage of revocable living trusts and moving that property, transferring that property into your trust. So that's a good option, even though it's not the same as we talked about just naming an individual on that ladybird deed here in Florida. You would have to go a couple more steps further to protect that other property. But obviously, again, you would talk to your attorney and you would see, what's worth it. Because if you have property out of state and you live here, to avoid not only probate here in Florida, but then ancillary probate in that other state where your property is, it may be very well worth it to invest in a trust.
And also, what I was referring to was automobiles, IRAs, other assets that you might have business interests.
So they're all treated different. There's different solutions for every asset. If we look at cash accounts, so bank, checking, savings, money markets, most of those, if not all of those, have a capability of having a beneficiary designation. Most people are very aware of that. They fill that out when they sign up for their checking account. The banks call it a POD, payable on death, but it's a beneficiary designation.
Same for investment accounts and those sorts of things.
Retirement accounts, investment accounts, they likely won't call it a POD. They'll likely call it a TOD, so a transfer on death. But again, it's a beneficiary designation. So there are ways to name beneficiaries on pretty much all of our accounts here in Florida. And, that is one of the ways we can avoid probate. Again, it's not a guarantee because there's risks associated with everything. So if we name an individual as a beneficiary, one, they should be an adult. They should be capable of managing and handling an outright gift of whatever the property is, whatever the asset is. And they should not be disabled because there are consequences to leaving lump sums of money to somebody who is on government aid. So it's not that we want to cut them out of our estate plan, of course not, but we want to just plan accordingly for them and make sure that we've properly planned for that person. So even though it is a great solution for a lot of people, it's not a one size fits all by any means, because you may have children who are minors. And so this wouldn't be a great option to name them as beneficiaries to everything. And so that's why it's good to really figure out what your goals are and where you want to go from there. And something that may be a good solution for you today may not be a good solution for you in 5 years.
What about vehicles, RVs, boats? That's a title situation.
Yeah, those are probably the easiest to deal with. The DMV is actually, nobody wants to go down to the DMV, but they're easier to deal with and faster to deal with than going to court. So I just had a situation where a client of mine passed away, and he had 4 adult children, and we prepared a last will and testament for him, but we planned to avoid probate through other means, other mechanisms. And so everything has avoided probate except there's his car. And so he does not have a loan on it. So there's no payment. So he has the title free and clear. So it's very, very easy for the son to take the title down to the DMV, take the death certificate down to the DMV, and take the will that hasn't even been probated down to the DMV. And the DMV gave him paperwork that has all 4 of the children sign off on it. And it's as easy as that. It sounds burdensome when you're like, oh, I have to have all 4 of the children sign off on it, and they're all in different locations and out of state. But it is a lot easier than having your whole estate go through probate and it be 6 months to 2 years or more.
Very good. So these individual options could be an alternative to a living trust. And I just completed a living trust. It was pretty comprehensive. It still involved some time for me that I had to put in. But I talk about the benefits, or first, let's go ahead and define it. And we should also talk about an irrevocable living trust at some point, although I don't think that's as prevalent. But talk about living trust vis-a-vis going to all these institutions to just do it piecemeal.
Yes. So no matter what your estate plan looks like when you're talking about trying to avoid probate, and the key is trying to, because of course we can't guarantee that, but you're going to have homework. So whether you are updating all of your beneficiary forms to name your adult children as the beneficiaries to your checking account, or your retirement accounts, or your real property, it's going to be work. So I always caution people coming into the process that once we are done with our process of preparing your documents, I send you with what your homework is, and I give you instructions of exactly what you need to do to make sure that your plan is successful. And so one of those things is, if you're looking at a revocable living trust, a revocable living trust is essentially a basket where you can put all of your assets in, and you can dictate instructions of what you want to happen to those assets if you were incapacitated, if you were simply in old age and no longer wanted to manage them yourself, needed a little bit of extra help, or of course at death. And that option, that revocable living trust option, is great for people with minor children, great for people with beneficiaries who may have a disability, great for blended families, or anybody who has a beneficiary who may not be able to accept a lump sum of money. So if they have a known addiction problem, or if they're just young and immature, maybe at the moment, you think back to when you were 21, and if you were given $100,000 or $500,000 or potentially more, Vegas may sound really nice. So putting those protections in place in that revocable living trust, having it private, so it's not like a last will and testament that's going to be published with the court, and having it be much more efficient than probate, because you have your trustee going through, acting very similar to how a personal representative in Florida would act, or other states may call it an executor. But instead of having the court sign off on it, they basically just have a fiduciary duty to follow the directions in the document. A lot of them will seek counsel, they will go to an attorney for help with trust administration, but it's a much easier and less gruesome process, or time-consuming process, than probate would be.
Let's go ahead and define irrevocable trust and differentiate between that and a living trust.
Sure. So
revocable.
Exactly. So a revocable living trust is essentially a pseudonym to yourself. So if you set up, let's say John Smith sets up the John Smith Revocable Living Trust, he can revoke, amend, restate that trust at any time pursuant to whatever the provisions in the trust say. So it's a good option if you have a young family. It's a good option if you still want control over your assets, as most people do. So you still are fully in control. There's no tax changes, which is nice. So you don't go get a new tax ID. You simply still use your social security number. You still file your same taxes at the end of the year. And it's essentially just a pseudonym. So instead of an asset being in your name, it's in the trust name, which is a pseudonym to you. But it allows provisions in there to state what you want to happen if you're incapacitated, how you want to be cared for, how you want your money spent, what happens once you pass away, where you would want your assets to go, if it's held in trust or not. Now, when we talk about an irrevocable trust, some people call it irrevocable, irrevocable. That means that you cannot change it. You also typically are giving up control over your assets. So I explain to people that if you're willing to gift your assets away today, but you have control over where they go, would you do that? And the answer for most of my clients who are middle income individuals is they don't want to do that. And the reason being is they need their money to live off of. It's one thing if you have millions and millions of dollars and you can easily gift money away and not have to worry about needing it in the future. You're not worried about, are you going to be able to pay your medical expenses? Are you going to be able to pay your mortgage? Are you, what happens tomorrow? So it's a great solution for larger estates. It's also a good planning technique for people who are looking at Medicaid planning. So Medicaid planning is very, very specialized. I won't get into too much of the details of it today because it's really its own bear. But for Medicaid planning, you have to plan at least 5 years in advance, and you have to be willing to give away your assets to this irrevocable trust.
Is it Medicare or Medicaid that we're talking about?
Medicaid. So Medicaid is need-based. Medicare is age-based. So when you are 65, you qualify for Medicare, you go sign up for it. Be sure you do so even if you don't need it when you're 65, even if you're still working, make sure you sign up for, whatever the first part of it is. Medicaid is need-based. So it's government aid for medical bills. A lot of us talk about it in the aging community for nursing home care, because that end of life care, whether it's in your home or in a nursing home facility, can be extremely costly. And so planning in advance for that is something that I always talk to my older clients about and see if they're ready for it, and see if they want to do it. So those are questions that I ask, when you come in, when we're talking about your goals and I'm looking at what your assets are, what your family makeup is, we'll talk about if you're a candidate for an irrevocable trust. Most of my clients aren't, and that's okay. But those are the two distinctions. The major distinctions are going to be control over those assets and being able to change it once you sign the document. So once you sign the revocable living trust, you can change it, you can amend it, you can revoke it, which means revoking would mean essentially deleting it, right? Like you want to take it back. Amending it would just be changing certain provisions. And then a restatement may be, if you've changed it so many times, you may be in need of a restatement, which is restating the entire trust so that it's less confusing for the people following along. Instead of having 4 amendments. It's better just to start over at that point. Versus an irrevocable trust, once it's set, it's kind of set in stone. And when you fund it, you know, those assets are now in that trust. That trust has to get a tax ID number, and it has to file its own tax filing at the end of the year. It doesn't necessarily mean it's going to be paying taxes, depending on the distribution structure of that trust, but they have to file taxes at the end of the year.
Do the beneficiaries of a irrevocable trust, are they taking on the tax burden? So if there is a tax liability, they are either together or separately or in some proportion accepting that tax liability?
Potentially, it really depends on the structure of the trust. So, a lot of times a good structure would be distributing all of the income from the trust. If it's income generating, right? We want to distribute that income to the beneficiaries so that they are reporting that income on their tax filings, which is probably a lot lower than if we keep it all nested together in a trust and pay the trust tax rate, because trust tax rates are a flat rate and they're pretty high. So you can a lot of times get away with paying less taxes if you distribute that money out. So yes, they would be required to pay taxes, whether it's in the trust or distributed out in that circumstance.
Okay. So let's go back to revocable living trust, which is going to be applicable to the most people, and that's what I created. And let me ask you this question that I've wondered about recently. Let's say I passed away and I pass a stock account, investment account that's not a retirement account to one person. Are they taxed on that income?
So if you leave a traditional trading account to somebody, so just stocks, bonds, whatever, in that traditional trading account, they would receive a step up in basis if you passed away. So when they received that account, they would get a step up in basis. But yes, any income generated from that, they would get a statement, just like you got a statement at the end of every year showing your income if they've sold anything, right? And capital gains and things like that. So yes, they would still be required to pay taxes. That's not a long-term tax avoidance strategy. However, it's a good strategy to step up somebody's basis in if you purchased XYZ stock for $10 and now it's worth $100. If you turned around and sold it, you would be paying capital gains on that $90. Whereas the next person in line, if they were to inherit it, would get a step up in basis. And then if they turned around and sold it for $100, and they wouldn't be paying that capital gains.
But if you just pass the principal to that person, they're not having to pay a tax as if it's income, additional income.
Right. So correct. So the bracket right now for estate taxes, federal estate taxes, is about $13.5 million a person. So if your estate in total is worth less than $13.5 million, then you can transfer your assets at death to your beneficiaries tax-free, meaning they won't be paying estate taxes. Now, here in Florida, we don't have state estate taxes, so we only have to worry about whatever the federal estate tax exemption limit is.
Okay.
But it's different for tax deferred accounts. So that's kind of the only account that I really like to make sure I talk to my clients about when it comes to taxes. I typically don't give tax advice. I am not a CPA. Not a tax professional. I can give you an understanding of what happens when you pass away in relation to taxes, but it's certainly not tax advice by any means. It's simply saying if your estate is less than this year, if you passed away and your estate was worth less than $13.5 million, your assets would transfer to their beneficiaries tax-free, meaning your beneficiaries would not be paying 40% estate taxes on that inheritance. They would get a benefit when it comes to taxes through that step up in basis that we talked about. So let's say the house that you own is, you bought it for $100,000. Now it's worth $500,000. They get a step up in basis. And so they're not paying that capital gains, that 15% capital gains on that $400,000 increase of what it was worth from what you bought it to now, right? So that's a huge tax benefit that people don't always talk about. The only account that you really have to be more wary of when it comes to taxes is going to be any tax deferred account. So retirement accounts, 401ks, IRAs. It's not necessarily tax-free money. It's tax deferred money, just like you would have paid taxes on it if you were taking that money out. The next person's still going to be paying taxes taking that money out. It's still a huge benefit to leave it to a beneficiary, but you don't get to just evade taxes and never pay taxes on that money if you put pre-tax dollars into a 401k and then you pass away and leave that 401k to somebody else. They can't just take that money out having never paid a tax dollar on it. So that's kind of the misconception a lot of people think is like, oh, it's tax-free because it's inheritance. But if it's a tax deferred account, you still are paying those normal income taxes. It's not inheritance tax you're paying. You're not paying estate tax, but you're paying your normal income taxes on it.
But if I pass it to a child who is 30, she's not having to pay the taxes until she is cashing it out, right? And that would be when she's not 65, 72 or whatever the age is.
Not anymore, unfortunately. The laws recently changed over the last few years. So it's really good to talk to a knowledgeable financial advisor as well as a knowledgeable estate planning attorney to understand what happens to those accounts and how to name beneficiaries properly. Because under Secure 2.0, instead of having a lifetime to take out those minimum required distributions, instead of using somebody's lifetime to calculate that, the majority of the time now you're going to have to take that out within 10 years. There are, of course, exceptions to that rule, which is why it's so important to talk to the proper advisors. One of the major exceptions is going to be your spouse. So your spouse will still have what we call the stretch. So they can stretch out till their retirement age and not have to take those distributions. Otherwise, the exceptions are few and far between. So they want you to pay your taxes. So they don't want you to have another 40, 50 years of growth in those accounts before they're ever seen a tax dollar. That's what they're trying to prevent. So now it's a much shorter period of time.
Yeah, it seems like it would be fair if they had to start taking a distribution at whatever age I would have had to. And you said that's what's changed, right?
Yes.
It
So
used to be that way.
yeah, so you used to be able to leave it to a beneficiary and that beneficiary distributions would be calculated based on their projected lifespan. And now that has changed. So just be aware of it. You don't have to know every detail to that, but just know that a grandparent can't leave their IRA account to their 10-year-old grandchild and think that that 10-year-old grandchild can have the benefit of it growing for the next 60 years.
Right.
That's not probably going to be allowed. Of
Right.
course, there are exceptions to that. but just know that it's a much shorter time period for most individuals now. And so you'll want to not only talk to an estate planning attorney, but also, be communicating to your financial professionals as well. I always think that having good relationships with CPAs and financial planners are crucial part to the estate planning process.
Right. I just had an idea that I've never done on a podcast, but I want you to be the first to do it. Get up on your soapbox and give us 2 minutes of your best soapbox lecture.
About what, Mark?
Oh, about, sorry. Well, you've got some around trust, around estate planning, on the topics that we've talked about, but I'm sure you have some cautionary words of wisdom that most people don't know and that they should know, and that's your soapbox issue or a
So
couple of issues.
yeah, so there's probably a couple. I would say in Florida, having access to being able to add a beneficiary to your home is major, major. And unfortunately, fixing the problem after the fact is much more expensive and creates many problems. So I have seen where people have added other individuals to the title to their property, thinking that they are doing the right thing by, having that safety net, like somebody else is on the deed to my property. So if something happens to me, it'll automatically go to that other person. And what they do a lot of the times is I see they've gone to the clerk of county courts. They've gotten a quitclaim deed from the county. They filled it out. Everybody signed it. They think everything's great. And I've seen horrible mistakes on those quitclaim deeds. And the county court, the clerk of county court, is not giving you legal advice. She's simply handing you a piece of paper. So it is not up to her or him to give you that advice. And I have witnessed people in my office very, very upset when I tell them the news of what the consequences to their actions are and blaming that clerk of county court. And I have to say, it's not the clerk's fault. It was not a mistake on the clerk's end. You signed this paperwork. They weren't giving you legal advice. They were giving you a form. And so if they had sought legal advice beforehand, it would have been very inexpensive to deal with what their goals were. Unfortunately, because of some of the mistakes they made, it was major, major consequences. So tax consequences, because now somebody else is an owner of this property. Potential reassessment, potential dock stamps owed, potential liability now. So if something happens on the property, if somebody falls, who's named in that lawsuit? This third party who doesn't live there, simply on the deed because they thought that that was the right thing to do. And the saddest part may be that they didn't even title it correctly. So maybe they took people off of the deed and everybody signed it, not realizing that they took a name off. They thought they were only adding, but instead they were replacing. And that's super dangerous, right? Or they think, oh, well, if I pass away, then it'll go to the third person on this deed, when they didn't title it like that. It's not with rights of survivorship. The default in Florida, if you're an unmarried couple or unmarried persons, is it's going to be tenants in common. So it doesn't even accomplish what you want it to accomplish. It's not even going to the other person. It's still going to go through probate. Really seeing a lot of mishaps with deeds is one of those things that it's really upsetting, because I know people's intentions are good and they just don't realize how inexpensive it is to seek proper advice and do it right the first time. And then I think the other big issue I see is not planning properly for blended families. That is something that is really sad to see when you have, especially older couple marries later in life. They both have their own sets of kids. Maybe they're widowers, and they just remarry for companionship. And they say, "Oh, well, my spouse, they don't want what I have. It's for my kids." But the reality is those family law concepts that we all love to talk about, separate property, and that I own the home before the marriage and this and that, doesn't apply in estate planning. There's much different laws that come into play. And so when you run out and you get married, there are consequences to that. And what your spouse is entitled to legally is going to be different than in family law situations, and what your spouse's family may be entitled to. So planning properly for blended families is so important, regardless of whether you have separate property or joint property.
Great. So if someone wanted to reach out to you to schedule an appointment, give us website, email, and phone number, and any other way that they should contact you.
So our website, so my firm's name is Morehouse Will and Trust, and that is the name of my website, morehousewillandtrust.com. It's Morehouse, and then Will and Trust is all singular. So WILLANDTRUST. You will see our services and fees, our most common services and fees on our website. My email address for our firm is legal, LEGAL, at morehousewillandtrust.com. And you can call us at the new Tampa area code. There are not very many 813 numbers left in Tampa Bay. So we have a brand new area code. It's 656-500-1020. So that's 656-500-1020. And that's our firm number.
Awesome. Well, I want to thank you so much for some really valuable information that you shared today. I would like to have you back on because I'm sure we've just scratched the surface on what we could be talking about. So let's be sure to circle back and have you on again. So
I would love that. Thank you.
Good. So let me wrap up here. Thanks so much, Cara, for being on the podcast and talking about estate planning and your legal services. To learn more about Cara, be sure to check out her contact information down in the show notes. Those that she just gave us, we will have there. If you enjoyed the episode, please like, subscribe, and click the notification bell to make sure that you get all of our episodes and notified for it. So thanks everybody for tuning in, and we'll see you next time on the Outmarket.pro podcast.